The XYZ Company Global Expansion Plan. A host country staffing strategy can have many benefits for the organization. Hiring local employees can save on relocation costs and other hiring costs, such as visas, in comparison to hiring expatriate employees or transferring current employees out of the country. Hiring host country nationals for lower-level positions and positions that several employees may hold, such as the shipping clerk, machinist, and administrative assistant positions, will help the organization to save money on these costs. Host country nationals will have no language barrier in the country that they are living and working in. This is especially important for roles that will interact with customers, such as the administrative assistant and VP of sales positions. Host country nationals will also have a better understanding of the local rules, laws, and customs, leading to higher productivity from the start. Having an understanding of local rules and laws will be particularly important in the accountant position. Understanding the local customs will be particularly important in the VP of sales position, since this employee will be in a high number of business meetings and will socialize with customers. Hiring host country nationals for certain positions, such as the VP of sales position, can bring valuable business connections to the organization. Finally, a host country staffing strategy will enable the organization to build a strong employment reputation in the country by providing enhanced career opportunities for local employees. If the organization decides to fill the VP of sales and accountant roles with expatriate employees, it is important to plan ahead to ensure compliance with the laws, regulations, and required processes for visas and work permits in foreign countries. For expatriate employees who wish to work in Mexico, there are several steps that need to be followed. The first step is for employers to apply for a Mexican work permit on behalf of the employee through the National Immigration Institute. Employers will need to submit the required documentation, including the work permit application form, the employee's employment contract, a copy of the employee's passport, original copies of the employee's diplomas, certifications, and transcripts, the employee's CV, and documents related to the company, such as the articles of incorporation, a list of employees and their nationalities, and proof that the company has paid its required taxes. The cost of the work permit is 2,974 pesos, which is equivalent to $160.45. Once the Mexican work permit is approved, the employee will be issued a unique processing number, which they will need to be included when the employee submits their application for a temporary resident visa. Next, the employee must apply in person for a temporary resident visa at a Mexican embassy in the United States within 15 to 30 days of receiving their unique processing number. The employee will submit their visa application at the time of the appointment and will be required to pay a processing fee of approximately $36. Generally, if approved, the temporary resident visa is ready the same day as the appointment and will be affixed to the employee's passport. At this point in the process, the expatriate employee is able to travel to Mexico and begin working. The temporary resident visa is initially valid for 180 days. If the employee plans to work in Mexico past those 180 days, it is important for the employee to visit the National Immigration Institute to convert the visa into a temporary resident card. The temporary resident card is initially valid for 1 year and can be renewed for an additional 1, 2, or 3 years for a total of up to 4 years. After those 4 years, the employee must either leave Mexico or apply for permanent residency. The initial cost of a temporary resident card is currently $260.48, and renewal costs up to $405.61. There are several different work visa options for U.S. employees working in Ireland. The first option is the intra-company transfer employment permit. This work permit is meant for short-term transfers of employees within an organization to a work location in Ireland. This type of work permit is available to senior management, key personnel possessing certain in-demand skills, and employees in a training program. This work permit may be a good option for the VP of sales position to get the Ireland branch up and running, allow the VP of Sales to train Irish employees on the company culture and way of business, and increase communication between the U.S. and Ireland's locations. Second option is the Critical Skills Employment Permit. This work permit is available to employees who possess critical in-demand skills, qualifications, and experience, of which there is a shortage. The accountant may qualify for this type of work permit. The third option is the General Employment Permit. This work permit is available for all occupations unless they are on the list of excluded occupations. The permit is issued for a period of 2 years and can be renewed for up to an additional 3 years. After those 5 years, the employee would either need to leave Ireland or apply for permanent residency. The application can be completed online and must be completed at least 12 weeks in advance of the employee's start date. The cost of a general employment permit for a period of 6 to 24 months is $1,083, and the cost of renewal is $1,624. American employees working in Ireland do not need to apply for a visa to enter the country. However, if they plan on remaining in Ireland for more than 90 days, they will need to register with immigration in order to obtain a permission stamp and Irish residence permit. As of January 1, 2020, the minimum daily wage in Mexico is 123.33 pesos, or $6.50 per day. This is a 20% increase over the previous minimum daily wage. Wages are generally accounted for daily and paid weekly. In Mexico, the standard work week is 48 hours for daytime workers and 42 hours for night workers, Monday through Saturday. Work on Sundays is paid at an additional 25% of the normal daily rate. Mexican employment law provides mandated paid vacation time, a vacation bonus, and holidays for employees. In their first year of employment, employees receive a minimum of 6 days of paid vacation. This increases by 2 days per year for the first 5 years and 2 days every 5-year period after that. The vacation bonus is an additional 25% of the normal daily rate for those vacation days and is intended for employees to spend on their vacations. Mexican employment law provides 7 regular holidays per year. Mexican employment law also mandates payment of aguinaldo, or a Christmas bonus, to employees by December 20th of each year. Aguinaldo is in the amount of a minimum of 15 days' worth of the employee's regular pay. Mexican employees are entitled to 12 weeks of paid maternity leave and 5 days of paid paternity leave. Federal subsidies also provide coverage for sick and injured workers. Employees are covered at 60% of their normal pay rate for up to 52 weeks. This coverage goes up to 100% of the employee's normal pay if there is a work-related injury or illness. There are no laws in Mexico that require employers to offer health insurance to employees, though most employers offer this benefit in order to create a competitive benefits package and attract qualified employees. There are comprehensive laws in place in Mexico to protect Mexican workers from unjust termination. Unlike in the U.S., at-will employment does not exist in Mexico. Employment in Mexico can be for determined or indefinite periods. Mexican law also allows for trial and training periods during which the employer can decide whether or not to keep an employee. Determined periods of employment are temporary positions that last for a specific predetermined amount of time and are governed by written contracts. The maximum duration allowed for determined periods of employment is 6 months. If an employee's employment is terminated before the end of the contract, the employer must pay the employee for the full length of the contract. Indefinite periods of employment are considered permanent positions. If an employee believes they have been terminated without just cause, they have the right to file for reinstatement. If an employee is reinstated, the employer must pay them for lost wages of up to 12 months between their termination and reinstatement. If an employee is terminated without just cause, the employer is required to pay severance. Severance consists of 3 months of pay and an additional 20 days of pay for each year that the employee was with the company. In order to protect employees and keep unemployment low, only serious offenses are considered grounds for justified termination. These reasons include, but are not limited to, 3 unexplained or unapproved absences in 30 days, employee deception regarding skills or experience, intoxication at work, sharing the employer's trade secrets, an employee refusing to work or obey orders, deliberate damage to company property, employee theft, and imprisonment of the employee. Ireland is one of the most highly regulated areas for employment law in Europe, which means that it is important for businesses wishing to conduct business in Ireland to work with a lawyer to ensure that they understand and are in compliance with the local laws. All employers are required to provide employees with a written contract specifying all basic aspects of employment, including the place of work, job title, start date, pay details, terms and conditions relating to hours of work, time of breaks, and the period of notice which the employer and employee are required to give to terminate their contract. As of January 2020, the minimum wage is €10.10 or $10.94 per hour. The average number of hours worked in a 7-day period cannot exceed 48 hours. This means that sometimes employees can work more than 48 hours in 1 week, but over a 4-month period, the employee's average working hours cannot exceed 48 per week. Employees are entitled to a minimum of 4 weeks paid vacation and 9 public holidays per year. Employees are also entitled to 26 weeks of paid maternity leave and up to 16 weeks of additional unpaid maternity leave. Employees' positions must be protected during this leave. Employees are also entitled to 2 weeks of paternity leave. There are also leave policies in place for parental leave, adoption, and caregiving. Ireland has a good publicly funded healthcare system. Employers do not need to provide healthcare benefits to employees who live and work in Ireland. In Ireland, both employers and employees are required to provide notice before separation. Employers may terminate an employee without notice if there is serious misconduct. The standard length of notice ranges from 1 week for up to 2 years of service to 8 weeks for 15 or more years of service. The employer may decide to pay the employee for the period of their notice and not have the employee work during that time. Employees are protected by the Unfair Dismissals Act. This act protects employees from being terminated without just cause and ensures that proper procedures for employee termination are followed. If an employee appeals a termination and the outcome is in their favor, the employee may be reinstated or may be entitled to up to 2 years' worth of remuneration. Remuneration includes salary and any other benefits. Employees with more than 2 years of service whose positions are eliminated are entitled to redundancy pay. Redundancy pay consists of 2 weeks of pay per year of service plus 1 week of additional pay. There will need to be some adjustments made to the job descriptions and requirements for the positions that will be recruited for in Ireland and Mexico. The education requirements may need to be adjusted for applicants in Ireland. The school system in Ireland is structured differently than it is in the United States. In what is the equivalent of high school, students take a more specialized program of study. For the administrative assistant position, a specialization in business or a related program of study may be accepted instead of the secretary school certificate. In Mexico, the secondary education system offers many specialized vocational programs that may provide enough education and skills to qualify candidates for the positions such as shipping clerk, administrative assistant, and machinist. HR should research what required educational qualifications are appropriate for the labor market in Mexico. Additionally, tertiary school or university education leading to a certificate, associate degree, or bachelor's degree is becoming more common in Mexico, especially in urban areas. Depending on the area that the business is located, HR should research whether requiring a bachelor's degree for the positions of accountant and VP of sales when hiring a host country national is feasible. The laws regarding pre-employment background checks and assessments in Ireland are very strict. Employers may only conduct criminal background checks on employees if they will be working with children or vulnerable adults. Pre-employment drug screening is also not a common practice in Ireland unless the employee will be working with children or vulnerable adults. HR should consult with a lawyer familiar with employment law in Ireland before requiring any candidates to submit to these types of background checks. In Mexico, there are no restrictions on medical assessments, drug screening, or criminal background checks. However, unlike in the U.S., these assessments must be completed before an offer of employment is made. Employers may deny employment on the basis of denying a medical assessment, drug screening, or criminal background check.